Today we're going to be talking about the different types of dispute resolutions. Hello everybody, my name is Croessmann. I'm the managing partner of Croessmann and Westberg law firm. So you've set up your collection system, you followed it, but your homeowner is still not paying. So what are your options at this point? Generally, you have three different options on your next steps. The first that we're going to talk about is called mediation. So what is mediation? Mediation is the process where a neutral third party is hired to bring the parties together. What does that mean? Well, the mediator does not decide who is right and who is wrong. The mediator's job is to help party A try to come to a middle ground and party B come to that same middle ground and eventually come to some type of settlement. Mediations are a good tool, but they are not the end-all be-all. For example, you wouldn't have in a contract that we're going to go to mediation. Because it's non-binding, if the parties don't agree, there has to be some other alternative. Where we typically see mediation is used as a prerequisite. So before we'll go to arbitration or litigation, which we'll talk about next, we have to go to mediation first. And that's used typically as a cost-saving measure because the arbitration and litigation can get expensive and the parties want to try to negotiate in good faith, but sometimes it takes that neutral third party to help them. So what is your other option? Well, you have arbitration. Arbitration is very similar to mediation in that you use a private party, a neutral third party. But the difference between an arbitration and a mediation is that the arbitrator actually makes that decision of who wins and who loses. Arbitrations, you do put on evidence similar to trials, whereas in mediations you typically don't. But you will put forth your evidence, you will examine witnesses, and at the end of that, the arbitrator will write that award of who wins and who loses how much. Then you take that arbitration to court and you get it recorded as a judgment. So what are the pros and cons? Pros are that it can be a lot faster than going to court. Arbitrators can also be somewhat specialized. For example, they may have some type of knowledge about a specialized industry. For example, in our law firm, we do a lot of arbitrations because the arbitrators are usually construction lawyers or retired judges that have some kind of focus on construction. So they have a lot of in-depth knowledge versus a judge who may never have had a construction case in front of them before. They don't bring the same amount of knowledge as that arbitrator who may be a construction lawyer and when they're not acting as the arbitrator. So that's good. However, you also have to pay a cost for that. In arbitration, you are paying, it's usually split between the parties 50-50, but that can vary depending on agreement. So for example, if your arbitrator is charging $400 an hour to review, listen to the case, and then write that decision, you're paying $200 an hour, half of that arbitration fee, plus any cost you're paying your attorney. So it can get quite expensive. For my clients that are remodelers, we actually don't recommend it because of the cost, but it certainly can be a very good option. If you're doing bigger jobs that are more complex or you're doing commercial work that can be really complex, then it certainly could be a very good option for you. So what's the third option? Well, the third option is going to court. Simple as that. And court is the default option. So what do I mean by that? Well, if you don't specify in your contract that you're going to go to mediation or arbitration, you're not going to be able to go. You can always come to an agreement afterwards once a dispute has started and say, well, let's go to arbitration. You can come to an agreement that way. But if you don't have an arbitration clause in your agreement, more than likely you're not going to be able to go to an arbitration association or company and say, I want to arbitrate, because arbitrations rely on both parties agreeing to be part of that arbitration. There are advantages and disadvantages to going to court. Some of the advantages are it can be cheaper depending on a variety of circumstances. If you have a small claim, court may be a very good option for you. Typically, most courts have a small claims division that are made to keep the legal costs down and also expedite those cases through. On the flip side, if you go up to circuit court or higher courts, it may be very expensive because there's more tools for the lawyers to do. Discovery mainly is the most expensive part. The other thing that could be a disadvantage is the time. Courts are backlogged. You have to fit into their docket. Where you fall is where you fall. To go to trial will typically take a year depending on the jurisdiction. Arbitrations are typically faster depending on the size. The benefit though is that it could be cheaper and that you're not having to pay the judge. Tax dollars pay for those judges. So you got to really talk to your attorney and figure out which system is best for you based on your expected claims. And then write that into your contract. Again, if you don't write into your contract that you're going to go to mediation before you're going to go to arbitration, then you're not going to do that more likely. Or you're going to go to mediation before you go to litigation. Those are things you're going to have to write into your contracts. But I hope you enjoyed the video. Next video, we're going to be talking about how to actually collect the money once you win.